Hello, hi, welcome to our commercial law lecture on the law of agency. And I'm David Chang. And today we want to examine this particular topic within agency on the doctrine of apparent authority. By virtue of this phrasing or this label, apparent authority, this refers to authority that the agent has which appears to a third party. What is apparent to a third party? And we know that this is a doctrine for which will enable the acts of the agent to be binding on his principal because of this authority that appears or that is visible, that is apparent to a third party, even though that agent may not actually have actual authority. And so this is an extremely examinable area where we want to understand what are the requirements in order for the principal to be bound by such appearance of authority by his agent, even though that agent may not be having such actual authority. In this regard, in particular, we want to look at this very important issue of where sometimes an agent may himself be making the representation of authority, saying that he has the authority from his principal, saying that his principal agrees with him to enter into the contract with a particular third party. And in reliance of that representation of authority, which is made by the agent himself, the third party contracts with the agent, only to discover that in truth, in reality, that principal had never made such a representation or agreed to such a transaction. So would that principal now be bound to that contract made by the agent? The issue being, one more time, where the agent had himself been the one to make that representation of authority, and it never did come from the principal himself. This is an area that we also call as a self-appointed agent, or what we call bootstrap agency, where the agent is attempting to pull himself up with his own bootstraps in making the statement that he has authority. And so we know that there are these two cases that are extremely important by the House of Lords, the cases of the Ocean Frost and First Energy. Both of these cases seem to provide different conclusions. So for example, in the Ocean Frost, and we covered this in a previous video, for which that was a case where the court had indicated that there's no such possibility of an agent to represent himself as having authority. And so in the Ocean Frost, the court concluded that there was no apparent authority because the representation of authority had come from the agent himself only. And in contrast, in First Energy, the court recognized, in a very controversial judgment really, where the court recognized that yes, that there was this doctrine of apparent authority and that the agent might be said to be able to possess such authority to bind the principal, even though the representation of authority came from the agent himself. So how then do we reconcile these two cases? And so when we examine various factors by looking at the facts of the cases, this will be the 6 factors I can identify that you would want to remember or to use in exams, and this is by virtue of the acronym of S.T.A.R.K. S.T.A.R.K. Hopefully this will help you to remember easily these 6 factors. And the first factor, S, would be to look at the status of the agent. Whether or not is he a junior agent, a senior agent? Is it someone that is in a position where one might believe him or regard him to have the authority to communicate to a particular transaction? What is the status of that agent? Then T would be in relation to the type of representation. Obviously, depending as to the status of that particular agent or the level or capacity or position of the agent, our point 1 above, then such an agent would be recognized to be making certain types of representation. So for example, if you are a selling agent, someone involved in selling, then obviously you would have the authority to make statements concerning matters about sale, although it may not involve anything concerning, say, a manufacturer's warranty, because that would be something that maybe a manufacturer may say but not a selling agent, as one example. Or it could be where this is a selling agent and he may make a representation as to credit in saying that, well, these goods you can buy and pay on credit. And so perhaps it may be said that if you are just a selling person or a selling agent, that type of representation as to credit is not something which can be common within that industry. And so maybe the court may then say that the agent ought not have made such a representation of authority. Although, having said that, in both my earlier examples, it does depend on the type of contract or industry, because we do know that insofar as agents who sell products or goods, it is not uncommon for them to obviously make statements or types of representations concerning a warranty of a manufacturer or concerning credit terms. And if that is a type of representation where it's common or usual to be given by someone in his position or his status, then therefore this is an agency for which the agent would be allowed to make statements or representations, and it will be binding on that principle. And so the third factor, A, would be whether or not would this be an agent who is placed in a position to having the authority to communicate approval. And so you can see how in this third factor we are drawing a distinction between authority to approve versus authority to communicate approval. No doubt that agent would not have any authority to approve or to enter into that transaction, but it may be that he was in the position placed by the principal to have the authority to communicate approval. And if he has done that, then therefore this would perhaps be binding on the principal. Indeed, if you are familiar with the facts of First Energy, that was precisely what the court emphasized on, with the House of Lords recognized that the bank manager in question, even though he had no authority to approve and he had acted outside authority, but because of his position, he was recognized to be someone who had the authority to communicate approval. And that is exactly what he has done. And this was a position for which the principal, the bank, had placed him in to grant him the authority to communicate approval, and accordingly, that's why the principal was bound. Again, you should refer to the earlier video lecture I did on this, where it was the facts of Ocean Frost and First Energy. It was an animated video, and it will allow you to see clearly what happened in those cases, and of course with your own reading to understand more of this point 3 or this whole lecture as well. Now the fourth factor is R, and that is to examine or to ask whether was it reasonable for the third party to inquire further. Sometimes it may be that the type of representation made is so radical, it's something for which ought not be said by such an agent in his status or position, and that would put that third party to notice for him to inquire further. And so we want to ask, is it such a situation that the third party ought to have, and that it is reasonable for him to make further inquiries, and not just so simply to accept or to take the representation of authority made by the agent himself? And if that third party had failed to make such inquiries, then he should not be permitted to allow on this doctrine of apparent authority. This in fact was also a similar distinctive factor or feature in the two cases of First Energy and Ocean Frost, where in the case of Ocean Frost, the court said that the third party ought to have made further inquiries, especially because he knew that the agent in the first place had no authority to be making such a representation. And this is related now to also point 5, dealing with the type of contract. So look at the contract. And what kind of contract is this? In the Ocean Frost, this was a charter party contract, whereas in the case of First Energy, it was an approval for a bank loan, a bank or bank loan contract. And depending as to the type of contract, depending as to who that agent was and his status, depending as to the type of representation made, it may be said to be reasonable for the agent to be making a representation of authority even though he has none. And so you can see how all these factors are related. It's not just looking at one or two factors, but that they're all related. And so, in the case of Ocean Frost, the court found that if this was a charter party contract and it was well known, and in fact known to the particular third party, that agent had no authority to make a long-term charter party contract. And so, since that is what the third party had done, to enter into a contract with someone they realized or that he knew would not have the authority to make such long-term contracts, then therefore obviously the principal ought not be bound by that unsupported reliance of the third party. So look at the type of contract. And the last one, K, which is related again to my earlier point and all the earlier points, would be the knowledge of the third party. Did the third party know, or should he have known, of the lack of authority by the agent? In the case of Ocean Frost, as I mentioned earlier on, the third party knew that the agent lacked the authority to make such contracts, such long-term contracts. And so if you had known, or you should have known, of the lack of authority, then you should make further inquiries. That was my point 4. Also recognizing, number 1, the status of the agent, where this was an agent that was known not to be able to make such long-term contracts. And so overall, the court found in Ocean Frost that the third party, knowing that there was a lack of authority, and yet he relied on the agency's representation, that is something that the principal ought not be bound to. Now, of course, even in the case of the First Energy, the third party actually was also aware that the agent in question had no authority to approve. And so in this regard, this last point or sixth factor is similar or somewhat similar in both cases, although it resulted in a different conclusion in the facts, but that was because in the First Energy, there were additional or other exceptional factors. For example, point 1, the status of the agent, in that this was a bank manager. Point 3, the fact that this bank manager, although he had no authority to approve, he had authority to communicate approval. And so, as I was saying earlier on, if one were to examine all the factors holistically, one would come to a conclusion that in the First Energy, the case in that sense was not wrongly decided, for the court to conclude that there was a valid agency, there was the doctrine of apparent authority in what the agent had done in representing as to his own authority. Now, so we are still, in a way, back to square one, wanting to really understand how to reconcile these two cases. No doubt we now have 6 factors, but I think it's important for us to examine the underlying or the overriding and the ultimate most important factor as to whether or not one ought to follow the decision or judgment of Ocean Frost or First Energy, and that is to look at this key point of a balance to be struck between principals and third parties, and to look at overall, based on the facts that we are examining, what ought to be that reasonable balance in the protection of interests of a principal and the protection of interests of a third party. Would it be a circumstance for which the principal ought to be protected in not allowing the agent to simply make statements that will bind him, such as was in the case of the Ocean Frost? Or is it a case of where the third party ought to be protected instead, him being the bona fide, innocent, vulnerable third party, and the principal should take the liability for actions of his agent, this being the case of First Energy? And so, depending on the case-to-case basis, and the balance to be struck based on a court's discretion is really how we understand these two cases of Ocean Frost and First Energy. These two cases, the facts are different, it can be reconciled. These are the 6 factors of S.T.A.R.C.K, S.T.A.R.C, for us to then use these 6 factors to conclude by examining the balance to be struck between the principal and third party to see whether should we allow for an agent to make representations as to his own authority. One final slide on this point would be to examining the post-first energy or post-ocean frost cases to examine what is the current position today, because we do now have a case by the Privy Council, Kelly and Fraser, that had affirmed first energy. So despite first energy having been a case that has been criticized, doubted, but yet it has received approval or affirmation by the Privy Council, but the court said this, that whilst the agent may not have the authority to approve, but if he had been placed in such a position by the principal to have the authority to communicate approval, and that is what that agent has done, to communicate approval, it's only right for the principal to be bound. And so you should look at the facts of Kelly and Fraser, and based on its particular facts, it was true that this was a particular agent where it is usual, common, understood for him to be able to make such statements, even though he was not authorized to do so, but because he was in a position to communicate the approval, as opposed to approve. The court allowed for this doctrine of apparent authority to arise. But lest you think that this area is resolved, it is not true, because here is now a conflicting position or case. This is a Singapore case, but it's by the Singapore's highest court, Court of Appeal, the case of Scandinav Visca and APB, where the case gave a very strong dissenting, or rather judgment that disagreed and that criticized first energy. And here is where the court stated that one must pay particular attention to the type of representation made by A. And this was the same point I made earlier on in the previous slide, or the type of representation. In that, we want to draw a distinction between whether or not would this be a representation made by the agent in relation to general matters, maybe for example as to quality of goods, time of delivery, credit terms. Is it on general matters, as opposed to a representation of approval? And so if one were to draw such a distinction, whether is it on one hand a representation by the agent on general matters, as opposed to representation as to approval, it is this latter representation of approval which goes to the heart of the agency, and the court held that in such instance the agent must have actual authority to do so, and that apparent authority is insufficient. And so therefore the courts were of the opinion that first energy's principle might not be a very accurate principle. It is to be doubted, because in first energy this was indeed a representation concerning approval, and that is something which is important or fundamental. In other words, the court is now saying here that no doubt an agent may have made certain representations, and in asking whether that representation ought to bind the principle or not, one have to pay particular focus to the type of representation. And if this was a type of representation that goes to the root or the heart of agency, i.e., in this instance now dealing with approval, then that is something that the agent may or must have actual authority to do so, failing which there ought not be any apparent authority and the principle should not be bound. If one were to examine the comments given in this case, this is reflective of the earlier balance I mentioned, that we ought to strike a fair balance between the interests of protecting the principal and the third party. And in some sense, if this is such an utmost fundamental important type of representation, surely the balance should be in favor of the principal, that it should not be bound because it never did authorize the agent to have the authority to approve. In this regard, you find that these two cases now currently would be how you can raise the discussions or arguments provide your own thoughts, but be aware of the possible conflicting conclusions and positions that can be taken. And so this ends our recording for this session, where we had looked at the conflict between the ocean frost, the first energy. We had looked at these two current cases of Kelly and Fraser and the Singapore case to understand more of how, although there is a way for how we can reconcile these two cases by using the acronym of S.T.A.R.C, S-T-A-R-C-K, but yet it is still to be decided on a case-to-case basis. And so likewise in the examination, based on the facts that you see and the similarity of the cases in your or the facts in your exam question, you then discuss and conclude one case, ocean frost, or the other, first energy. So with that, thank you very much for watching this video. And if you have enjoyed this video, feel free to subscribe, to share, and to like. Thank you.